Okay, let's get started with Chapter 3, Federalism. And as you saw in the video, talks about the United States and its relationships between its states. And that's what we're going to focus on today is that relationship. And that relationship is called federalism. We have what is known as a federal form of government, and it differs from other systems of government in the world and in the past. And we'll look at why it exists in the United States and how the Constitution divides the governing power in our federal system and how the relationship has changed. And then we'll describe federalism in recent years and what fiscal federalism means. Well, federalism and the alternatives to federalism and why it's an optimal choice are important things to consider in defining federalism. The conflicts you saw in the film arise because our government is based on the principle of federalism. And we talked about the marijuana situation in that video, but basically what it means is that government powers are shared by the national government and the states. And when the founders of this nation opted for it, they created a practical and flexible form of government capable of enduring for centuries. But at the same time, of course, they planted the seeds of future conflict. Now, the powers of the national and subnational units are specified and limited. The national government has specified powers granted by the Constitution. Sometimes they're called delegated, enumerated powers. And these also possess some implied powers that can allow Congress to undertake actions necessary to carry out its express designated powers. Then there's reserve powers, and we'll get into those in more detail. But it is a complex system shown in this 19th century government diagram of the federal government and American Union, where you have these 50 states, and then at the top you have the three branches of government, the courts, the executive branch, the legislative branch, the House and the Senate. Then you have all these different departments in the federal government, and then you have the states, and they each have their own branches of government within them. Now, federal systems are practiced in other countries. This table 3-1 shows you those countries. Notice how there are large countries like Russia, Australia, Canada, Mexico, Brazil, Argentina, with large populations, the largest being India, with, I believe it's 1.3 billion people. Some nations call their sub-regional governments or subnational governments provinces. Germany, the United States, we call them states, as does Mexico, but they're nevertheless subnational or regional governments. Now, to further complicate matters, as you saw in the video, the term federal government refers to the national or central government, but then there's also, the government over DC, which is the federal government, and then there's the territories, there's the Indian reservations and the islands and so on. So it can be a bit of a confusing situation. Maybe a better way to define it is to discuss what it is not and what a majority of countries are in the world today. What a majority of countries are unitary in their system. And now such a system vests all their powers in the national government. And if the national government so chooses, it can delegate some activities to subnational units. So subnational units are creatures of the national government. For example, in Great Britain, you have the unitary government in London, and then you give powers to the subnational units like Scotland at the regional level. Scotland is this area up here in yellow. or you give it to council areas, or parishes, or metropolitan counties, and so on and so forth. But each one of these different levels is a subnational government and a creature of the national government. So power can be taken away. Now, in the United States, on the other hand, because the Constitution does not mention local governments, we say that cities and county units are creatures of state governments. And also, the Congress and the Constitution does not allow, is not allowed to dissolve state governments. They cannot be eliminated, they cannot be removed. Most of these unitary governments tend to be more dictatorships or authoritarian in nature. The darker the nation, the more authoritarian, the more controlled by a central governing body, a group of leaders, an oligarchy that surround a dictator. Now, another form of government that doesn't exist many times in our history or in the world today is the confederation form of government. We had one under the Articles of Confederation, which created a confederal system. And this has the national government exists and operates only at the direction of the subnational governments. And there are few true confederal systems in existence today. Some say that the European Union, shown here on this map, is an example of a confederal system, a group of 28 European nations, and they've established many common institutions. Now, in 2016, Britain voted to leave the EU, and that was going to be effective 2019, but here it is 2020, and it's still not fully effective. Now, what are some of the, why did we go to the federal form? Well, because the Article of Confederation form failed. It didn't allow for a sufficiently strong central government. Now, the framers were also fearful of tyranny and a too powerful central government, so they came up with this compromise system. They kept the states, but they created a national government or federal government. So the appeal was that it retained state powers and local traditions while it established a strong national government capable of handling national defense. Now, one of the big advantages that it really suits the United States is our country's large size. Even when we were 13 states, we were bigger than England or France. Now, if you look at figure 3-1, you can see to the great extent the practical business of governing this country takes place really in state and local governmental units. If you look at the chart here, you can see that, there are 3,000 counties, 19,000 municipalities, 16,000 townships, 37,000 special districts, 12,000 school districts. So 89,056 governments exist in the United States. And they enjoy substantial financial, administrative independence. Special districts are more concerned with specific issues like solid waste, mass transportation, fire protection. And the boundaries often cover several other governmental jurisdictions. Another advantage of federalism is it enables the government to experiment with innovative policies and programs. And we've had Supreme Court justices like Louis Brandeis emphasize that in the federal system, state governments can act as laboratories for public policy experimentation. Many states have adopted minimum wage laws, and these led to the United States adopting one. And California was a pioneer in air pollution control, and many of that state's regulations were adopted by other states and the federal government. It also allows subcultures. Regional groups can reflect in their laws their interests, their beliefs. Now, there are drawbacks. A single political group can dominate a political unit. Small political unit, powerful state and local interests can impede national laws. Lack of uniformity of state laws complicate interstate business transactions. This leads to businesses leaving one state and going to another state that can harm the state as a whole, cause high unemployment in one state. Coordinating government policies at the national, state, and local levels is difficult. So these are some of the drawbacks. Well, let's get into the constitutional division of powers in this country. So we'll go over that. Powers of the national government, powers of the state, the interstate relations, concurrent powers, and the supremacy clause. First, there's the express powers. And those are things that are probably known to you. Coin money, regulate interstate and foreign trade, conduct relations with foreign countries, establish post offices, govern territories, admit new states, grant patents and copyrights, maintain the armed forces, declare war, make peace, establish immigration and naturalization. Regulate commerce is a very important one. That is one power expressly granted to the national government, and this one receives a lot of attention in Supreme Court cases and disputes between the states and individuals and the United States and so on. The United States is the only entity allowed to deal with the Indian tribes. So that means that states cannot really limit their authority on American Indian reservations within their boundaries. Now, the implied powers would be the powers of the federal government that are implied by the express powers in the Constitution. So we have the express power to raise an army. So the implied power is that, well, the Congress can then draft people to go into the army, or develop new armored tanks, or construct military bases. It doesn't say those things in the Constitution. It just says raise an army. We have the express power to collect taxes, so that gives the Congress the implied power to establish the Internal Revenue Service or establish the National Bank. And the clause, the specific wording in the Constitution that the courts have interpreted to give the Congress this implied power is the necessary and proper clause, which is in Article 1, Section 8, Clause 18 of the Constitution. After all the 13 or so powers are listed, at the end there's this clause that says, Congress shall make all laws necessary and proper for the federal government to carry out its responsibilities. Sometimes it's called the elastic clause. Now, inherent powers, these are powers that the governments simply have to ensure the nation's integrity and survival. So we must have an inherent ability to make treaties, regulate immigration, acquire territory, wage war, make peace. It says raise an army, but it doesn't say make war. Now, while some inherent powers are enumerated, some powers are not. It doesn't speak of regulating immigration or acquiring new territory, but we do those things. So these things are older than the Constitution itself. The power to own land, for example, to dispose of land. In fact, much of the West, as you can see on the map here, is owned by the federal government. They can dispose of that if they want. Now, there's things prohibited to the national government. They cannot do those things that outlined in the first state amendments, as we saw in chapter 4, as we will see in chapter 4. Those are listed in the first state amendments. There's also some listed in Article 1, Section 9, such as they cannot pass a bill of attainder. There's also many that don't believe that the federal government has the power to create a national public school system. That's not in the expressed or implied powers. Now, the powers given to the states are called reserved powers because in the 10th Amendment of the Constitution, it specifically says that the powers not given to the national government nor prohibited to the states are reserved to the states or the people. So the 10th Amendment gives enormous powers to the states, including the power to regulate commerce within their borders, maintain a state militia, provide the health, safety, welfare, morals needed in a state, create cities, create counties. Mainly we call them police powers because reserve powers isn't specified, but we've tended to call them all that. Now, there's powers prohibited to the states. They cannot tax goods transported across state lines. They can't enter into treaties with other countries. If they want to enter into compacts with other states, they have to get the approval of the Congress. Now, as far as their relationship with other states, they are to honor the records, documents. This is called horizontal federalism. Now, this came up in the last 20 years with the same-sex marriage issue. In the 90s, Congress didn't like states recognizing gay marriages, and so the DOMA was passed, Defense of Marriage Act. But in the United States versus Windsor, this was struck down in 2013. And finally, in Obergefell, you'll see this in chapter 4, the courts found laws against same-sex marriage to be unconstitutional. So with that ruling, DOMA violated the full faith and credit clause and became irrelevant. So each state has to honor another state's same-sex marriage certificate. Now, concurrent powers are those held by the states and the federal government, and they apply within the geographic area of the state. Although the 6th Article, Clause 2 states that the Constitution and federal laws made in pursuance thereof shall supersede any state laws or local laws. Now, that's assuming that the laws made by Congress are constitutional, and sometimes they're not. And they are found to be not constitutional, oftentimes by the Supreme Court, as we'll see throughout the upcoming chapters. Now, in figure 3.2, you can see the summary of these powers given to the national government, these delegated and implied powers, and then the states' reserved powers and some delegated powers. And then you see where they overlap. That just means that they're similar, that the states and the national government have similar powers in certain areas. Both can collect taxes, both can borrow money, both can make laws, enforce them, establish courts, provide the general welfare, charter banks and corporations, and they're denied certain powers. National government cannot tax articles exported from any state. It cannot violate the first 10 amendments. The first 8 deal with our personal rights. And it cannot change our state boundaries. It cannot join us with another state, cannot dissolve our state unless the state consents to that. and Congress consents. It cannot and also the states and the national government cannot grant titles of nobility, cannot permit slavery under the 13th, cannot deny citizens the right to vote under the 15th. States cannot deny women the right to vote. That's the 19th Amendment. And states are not allowed to do those specific things on the right in the brown part of the circle here. Well, let's get into the evolution of the federal-state relationships in the United States. Much of the political and legal history of the United States has involved conflicts between the supremacy of the national government and the desire of the state to preserve their sovereignty. You know, the most extreme example was the Civil War conflict of the 1860s. Now, before that, there were several events, Supreme Court decisions, where the national government actually increased its powers. Two of which we'll get into a little more detail. Both were issued by John Marshall, Chief Justice, in his 34 years as Chief Justice from 1801 to 1835.
Make sure you check today. I didn't hear you talking.
Now, in Marbury versus Madison, Marshall clearly enunciated the principle of judicial review, under which the courts can determine that laws or executive actions are unconstitutional. And we saw that in chapters 1 and 2, where if something is challenged, it goes to the Supreme Court and they decide if something shall be in pursuance of the Constitution or violates it. And the Supreme Court does this by reviewing the actions or laws of the legislative branch. Now, the framers didn't call it a judicial review. They didn't foresee this, but they knew it would happen in this manner. A single person can challenge an existing law through a judicial hearing, and that's what's happened ever since, or a state or a government entity or a corporation. But in the two cases we're going to go over, McCulloch and Gibbons, you had individuals, one challenged an action by Congress, and the other was a dispute between two individuals involving the Interstate Commerce Clause. So let's look at McCulloch first. McCulloch involved the head of the Bank of the United States in Maryland, Mr. McCulloch, who refused to pay a fee or a tax to the state of Maryland. But this bank had been set up under the Second Bank of the United States law, and the federal government, national government, have established it. And Maryland, like many other states, was trying to control the commerce, control the expansions of these national banks, and wanted to impose a harmful tax. Now, Congress used its powers, its delegated power, and the necessary and proper clause, and the court found that the case did involve those two things, and said it's much more than a question of just taxes, but it's a question of implied national power and national supremacy. You know, yes, we understand, said Marshall, that no provision in the Constitution grants the national government the express power to form a national bank. Nevertheless, if establishing such a bank helps the national government exercise its express powers, then the authority to do so could be implied. Marshall also said the necessary and proper clause included all means that are appropriate to carry out the legitimate ends of the Constitution. Then they are legitimate if they're consistent with the letter and spirit of the Constitution. And then he had to address the idea of, can a state interfere with an activity chartered by the national government? And looking at Article 6, he declared, well, no state can use its taxing power to tax an arm of the national government. Otherwise, it could destroy that institution, and that would make the Constitution an empty shell or just meaningless. So this gave strength to the national government's power. Let's take a look at this Quimby video, and they'll sum up some of the
McCulloch versus Maryland may appear to be an old esoteric case about bank charters and taxes, but it's really about a power struggle of constitutional proportions between the states and the federal government. The consequences of that struggle continue to reverberate today. In 1816, Congress passed an act that created the Bank of the United States. A year later, the bank opened a branch in Maryland. To take a shot at the new, all-powerful federal government, Maryland passed an act in 1818 that imposed a $15,000 annual tax on all out-of-state banks operating in the state. The act appeared neutral on the surface, but it practically targeted the Bank of the United States, which was the only out-of-state bank in Maryland at the time. James McCulloch, the cashier of the Bank of the United States, refused to succumb to Maryland's pressures and refused to pay the tax. In response, Maryland sued McCulloch in Baltimore County Court. The trial court sided with Maryland and ordered McCulloch to pay the tax. The Court of Appeals affirmed, and McCulloch petitioned for review in the United States Supreme Court. The court was faced with two questions. First, does Congress have an implied constitutional power to create a bank? Second, if Congress does have that power, can states tax a federally created bank? The court held that Congress has the constitutional authority to charter the federal bank, and that the states are prohibited from taxing it. Chief Justice John Marshall authored the court's unanimous decision. Marshall was one of the most influential Chief Justices in United States history. Before his career on the court, a young Marshall had fought in the Revolutionary War. At the time, Americans instinctively thought of themselves as citizens of their state, rather than as United States citizens. But following Marshall's military service, Marshall came to think of himself as an American first and a Virginian second. This hierarchy is evident in his McCulloch opinion, which elevates the national government over the states. Marshall acknowledged that the federal government is one of limited powers, and that the authority to charter a bank does not expressly appear in the constitutional text. Nevertheless, Marshall concluded that Congress's powers extend beyond those that are expressly enumerated in the Constitution. Congress has implied powers as well as enumerated powers. According to Marshall, when the Constitution authorizes a particular end, Congress must also be given the implied means to accomplish that end. In support, Marshall cited the Necessary and Proper Clause, which authorizes Congress to make all laws necessary and proper to execute its express powers. Maryland argued that the phrase necessary and proper means that Congress can create only those laws that are absolutely essential to carry out its express powers. Marshall disagreed with this interpretation and held that the word necessary refers to anything that is useful or convenient for carrying out Congress's express powers. Applying this interpretation, Marshall held that a federal bank was useful for raising and distributing money, which related to Congress's express authorities under Article 1, Section 8. Under this section, Congress can tax and spend for the general welfare, borrow money, regulate commerce, and raise and support armies, among other things. All of these duties were aided by the federal bank. Marshall next went on to discuss whether the state of Maryland could tax the federal bank. Marshall famously declared, quote, "The power to tax involves the power to destroy," unquote. Further, Marshall noted that federal laws are supreme over state laws. Reading these two principles together, Marshall held that a state law cannot inhibit a federally created institution. He concluded that it would be inappropriate for a federal bank created to serve the entire nation to be subject to the taxes of a single state like Maryland. The court reversed the judgment of the Maryland court. But the conflict wasn't over yet. After the opinion was announced, Maryland's Attorney General instigated an indictment against McCulloch, the bank's cashier, for conspiracy to defraud the federal bank. In one fell swoop, Chief Justice Marshall announced a landmark decision that gave Congress broad implied powers to implement its express constitutional authorities. By doing so, Marshall shut down the states' rights argument brought by Maryland and set the stage for the continued expansion of the young federal government.
Okay, now in Article 1, Section 8, as he mentioned, the Constitution gives Congress the power to regulate commerce among the several states. But the framers of the Constitution didn't define the word commerce. So at issue in this one, Gibbons versus Ogden, was how the Commerce Clause should be defined and whether the national government had the exclusive power to regulate commerce involving more than one state.
Contrary to what your law professor may have told you, Gibbons versus Ogden is not merely about the Commerce Clause. It's about jealousy and revenge over a man's wounded pride and reputation. Aaron Ogden counseled the wife of Thomas Gibbons in divorce proceedings against him. Then, Ogden had Gibbons arrested for fraud of a banknote. After that, Gibbons made it his life mission to destroy Ogden. Gibbons challenged Ogden to a duel to reclaim his honor, but Ogden refused. As a result, Gibbons had no other avenue for revenge but to challenge Ogden's business interests. Ogden was licensed by the state of New York to operate steamboats. The New York license purported to give Ogden the exclusive right to operate steamboats in New York waters. Gibbons pursued and obtained a similar license from the federal government. Gibbons used the federal license to compete with Ogden in the same water route that Ogden was using. In an attempt to protect his monopoly license, Ogden sued Gibbons in the New York Court of Chancery. Ogden sought an injunction that would stop Gibbons from operating his steamboat in New York waters. Gibbons argued that he was allowed to operate his steamboat in New York waters by an act of Congress, which regulated coastal commerce. The chancellor disagreed with Gibbons and granted the injunction. On appeal, the Court of Errors affirmed. The question on petition to the United States Supreme Court was whether a state law is invalid if the law infringes on Congress's authority to regulate interstate commerce. The court held that Congress has the power to regulate interstate commerce, and that under Article 1, Section 8 of the Constitution, commerce includes navigation among the several states. As a result, a conflicting state law is trumped by the supremacy of Congress's authority to regulate interstate commerce. Chief Justice Marshall explained that Congress may regulate commercial activity when the commerce includes more than one state. The court emphasized that Congress cannot regulate the exclusively internal commerce within a state, but the navigation of steamboats from one state to another falls under Congress's power to regulate interstate commerce. After concluding that Congress has the power to regulate navigation between two states, the court concluded that any attempt by New York or any other state to regulate the operation of commercial steamboats must yield to Congress's law under the Supremacy Clause. Here, New York's monopoly grant of a license to Ogden conflicted with the federal grant of a license to Gibbons. The court reversed the judgment of the New York Court of Errors and ordered that Ogden's lawsuit against Gibbons be dismissed. Justice Johnson wrote a concurrence articulating an even broader understanding of the Commerce Clause. Johnson argued that the New York grant of a monopoly license to Ogden would be invalid, even without a conflicting federal license. Johnson reasoned that the framers intended to give Congress the exclusive authority to regulate interstate commerce, which completely excluded state regulation of interstate steamboat navigation. Gibbons versus Ogden was the first Supreme Court case to interpret the meaning of the Commerce Clause. Through its broad interpretation of that clause, the court set the stage for a significant expansion of the powers of federal government.
Yeah, that last word was the key phrase, I should say, the last phrase in that comment. The national government has used this Commerce Clause repeatedly in the last almost 200 years nowadays to justify its regulation of all areas of economic activity. Now, in the 1820s, late 1820s, 1830s, and 40s, um, the states started to reassert their authority, and there was a shift back to states' rights, so to speak. And this became a major issue in federal state relations, especially with the passage of what we call tariff laws, or tax laws on goods imported into the United States, because the United States couldn't tax exports, but they could tax things coming in, and southern states objected. They felt that these taxes were against their interest, especially states like South Carolina. Those areas in purple voted totally against these kinds of tariffs. In fact, one state, South Carolina, attempted to nullify these tariffs. That was the so-called nullification crisis. But President Andrew Jackson um, was not above using force, as he did in the War of 1812 against the British, and he wasn't opposed to using force to make sure the states observed that. So the states kind of backed down, and this reduced the tensions. So the crisis passed temporarily, but the states began to promote their own states' rights and defense of slavery, and that led to the South's decision, of course, in favor of secession or withdrawal from the United States. Now, after the Civil War, 1865, the southern states were defeated, and it defeated the idea of the right to secede. There was a Supreme Court case, Texas versus White, which makes that clear. And then there were the Civil War amendments, the 13th, 14th, and 15th, that abolished slavery, ensured that all people have due process and equal protection, and required states to recognize the rights of African Americans to vote. So there was an expansion of federal power during the 1860s, 1870s. But nevertheless, at the end of Reconstruction and really up until the 1930s, the relationships between states and the national government can be best described by a model that's useful in describing the evolution of federalism after the Civil War. And this model is known as dual federalism. And this assumes that the states and national government are more or less equals, which each level having separate and distinct functions and responsibilities and exercising those in certain matters. And states could regulate voting and economic items or social items. Many states passed segregation laws and those kinds of things, as we'll see in Chapter 5. So there was some efforts to exercise federal government authority under the Commerce Clause. Now, in 1918, the Supreme Court ruled a federal law that excluded from interstate commerce the products created through the use of child labor. The law was held unconstitutional because it attempted to regulate a local problem. Now, by the 1920s, 1930s, the era of dual federalism really began to crumble because of the greatest economic depression we've ever experienced. As we became more industrialized, more urbanized, people living in the cities, a new type of federalism, cooperative federalism, led to the growth of the national government. This was ushered in with the election of a Democratic Congress and President Franklin Delano Roosevelt. So he attempted to bring the national government into many of the affairs that state and local governments had tried to handle, such as public assistance. And this continues today, really, with some minor adjustments. Now, the Supreme Court had to agree, and up until the late 30s, they didn't want to do that, so he threatened to pack the court, much like the Democrats are threatening to do once they get power after the election. They want to expand the Supreme Court, add 6 new members who would presumably be more favorable to certain actions favorable to the Democrat Party. Now, this was considered an assault on the Constitution back then, and it is not playing well right now. And in fact, Biden and Harris are trying to avoid answering the question, do you support it? But in 1937, a few people retired, so Roosevelt was able to put people in that he wanted, and they were approved by the Senate. And so after 1937, the court ceased its attempt to limit the scope of the Commerce Clause. Now, in the 60s and 70s, the Great Society saw a greater expansion of the national government's role in domestic policy. The Great Society legislation of Johnson, like Job Corps, Head Start, and so on, this was part of that expansion. Now, there's another model in which every level of government is involved in implementing the policy. That's sometimes referred to as picket fence federalism. This is where the levels of government are the horizontal support boards, and the policy is the vertical pickets on the fence. Now, the cornerstones of the cooperative federalism is, of course, the Commerce Clause. That gives the power of Congress to regulate pretty much any type of economic activity, irrespective of where it happens. Sometimes it's been interpreted to extend beyond activities that actually involve interstate commerce. But nevertheless, it still is used. But occasionally, Supreme Court itself has curbed Congress's regulatory powers. And you will look at this in a moment. Another thing that it has allowed is preemption. Preemption just means that national laws governing a certain area take precedence over conflicting state laws governing that area. Obamacare, shown here, was a great example of, kind of a stretch of the expansion of the Commerce Clause, regulating interstate commerce. We're going to provide health care that has nothing to do with interstate commerce, but the courts in a 5-4 decision said it did. We'll see if that holds up. Okay, now let's get into federalism today and more power to the states, the Supreme Court and new federalism, and then the shifting boundary between federal and state authority. Well, beginning in the 1970s, the Nixon administration and others attempted to, under Reagan as well, attempted to revitalize the doctrine of dual federalism. Now, they renamed it New Federalism, but involved a shift from nation-centered federalism to state-centered federalism. One of the major goals was to kind of return to the states some of the control over policies that had been exercised by the national government since the 1930s. So they gave it a term, devolution, the transfer of power to these political subunits. That's often used to describe the process. And this even went through the Clinton administration during the 90s. A great example would be the welfare reform legislation passed by Congress in 1996 that you'll see in the video on federalism. And the Supreme Court furthered the cause of the states' rights in this new federalism during the late 1900s and early 2000s. A variety of these decisions either limited the power of the federal government or enhanced the power of the states, like United States versus Lopez. In this case, the courts, they felt that a Gun-Free School Zones Act of 1999 law, which banned the possession of guns within 1,000 feet of any school, was unconstitutional because it had nothing to do with commerce. So in 1997, the court struck down portions also of the Brady Handgun Violence Prevention Act. It forces state employees into federal service. It's an unfunded mandate. And in 2000, the court invalidated key provisions of the Violence Against Women Act of 1994, which allowed women to sue in federal court when they were victims of rape, which is, of course, punishable by state law. an interesting case forced the national government to act.
Originally passed by Congress in 1963, the Clean Air Act requires the Environmental Protection Agency, or EPA, to regulate the emission of pollutants that endanger public health and welfare. The Act also authorized state and local governments to enforce regulations, with oversight by the EPA. In 1999, a group of 19 private organizations petitioned the EPA, asking it to regulate the emission of carbon dioxide and other greenhouse gases from new motor vehicles. The EPA refused. The petitioners, along with several states that intervened in the lawsuit, including Massachusetts, brought suit against the EPA to determine whether the EPA had the statutory authority to regulate greenhouse gas emissions under the Clean Air Act. Massachusetts alleged that the EPA's failure to regulate these emissions would ultimately result in loss of its coastal lands due to increased global warming from the emissions. The EPA countered that any injury that may occur would be widespread and not a particular concrete injury to the petitioners, and that therefore the states, local governments, and private organizations lacked standing to bring the case in the first place. The Court of Appeals for the District of Columbia denied the petition for review, and the petitioners appealed. The U.S. Supreme Court granted certiorari. One issue on appeal was whether the petitioners could demonstrate a sufficiently particular and concrete injury in order to prove they had standing to bring this case. On the issue of standing, the court found in favor of the petitioners. Writing for the majority, Justice Stevens explained that when multiple challengers are involved in a case, only one of the petitioners needs to demonstrate sufficient standing in order for the court to review the case. Here, the court took special interest in Massachusetts' status as a sovereign state and based its analysis on whether the state was able to demonstrate standing. Stevens reasoned that because Massachusetts surrendered its ability to take action against other states when it joined the Union, the federal government has a special obligation to protect Massachusetts against harm from other states. Stevens explained that just as in a case brought by an individual plaintiff, an actual case or controversy must be present in order for the plaintiff state to have proper standing. An actual case or controversy is characterized by a truly adversarial relationship. A plaintiff can show the existence of a truly adversarial relationship by demonstrating that he has suffered a concrete and particularized injury that is either actual or imminent, that the injury is traceable to the defendant, and that it's likely that a favorable decision would redress that injury. Because Massachusetts was able to show that greenhouse gas emissions would further exacerbate the problem of global warming and ultimately cause the state to lose coastal lands, it had fulfilled this requirement. Additionally, the court found that the state was able to show sufficient causation between this injury and the EPA's failure to regulate greenhouse gas emissions because the lack of regulations contributed to the problem of environmental damage from greenhouse gases. Finally, although the impact would be small in light of the global problem of greenhouse gas emissions, the EPA's regulation of domestic emissions would in fact have an impact on decreasing the amount of emissions in the environment and thus reducing the amount of environmental damage to Massachusetts. Therefore, the court found that Massachusetts did have standing in this case. Chief Justice Roberts dissented, taking issue with the special status the majority conferred on Massachusetts. He explained that in any case, the petitioners bear the burden of demonstrating a particular and concrete injury that is clearly linked to the defendant's actions, and that a ruling in favor of the defendant would likely redress their injury. It doesn't matter whether the petitioner is a private citizen or a sovereign state. Chief Justice Roberts claimed that in this case, the petitioners had failed to introduce evidence that showed any petitioner, let alone the states, would suffer a particular injury distinct from harm suffered by anyone else. Roberts remained unconvinced that a ruling in their favor would do anything to redress their injury. This case is significant because it emphasizes that injury is a clear requirement of standing under Article 3. It also recognized that the states may have a lesser burden in establishing standing than private individuals. If you found this video helpful, you can explore all of our content by visiting us at quimby.com.
Well, I think that was helpful to understanding some of this new federalism. Here, the states kind of went the other way. They said, no, you got to spend some money and do your job and implement the Clean Air Act of 1990. The EPA said, we lack the authority under the Clean Air Act to regulate greenhouse gas emissions alleged to promote climate change, but the court said, no, EPA, you are required to regulate such emissions and should take steps to do so. So you can see the boundary between the federal and state authority constantly shifts, and there's constant debate in the courts, and they're constantly in this tug of war over federal regulations, federal programs, federal demands on states. Sometimes the Democrats are in favor of one side, sometimes the Republicans in favor of another. Republicans favored the No Child Left Behind under Bush. Now the Supreme Court weighs in, like in Arizona versus United States in 1912, they confirmed national authority over immigration. In healthcare reform, National Federation of Independent Business versus Sebelius in 2012, the court upheld most of Obamacare. That requires individuals to purchase something. That has nothing to do with the Commerce Clause, but that's what they rule. Now, should sanctuary cities be allowed? Well, those that believe the 11 million or so currently living in the United States without legal authorization, yeah, we should have sanctuary cities. Some say the Constitution protects them. Some would say, like on page 65, that the national government should crack down on these so-called sanctuary cities. Okay. Well, let's go over the fiscal side of federalism. Talk about the federal grants, categorical grants, block grants, the cost of federal mandates, and competitive federalism. Now, since the advent of cooperative federalism in the 1930s and its expansion in the 60s, what has happened is that some activities must meet a standard specified by federal law. That's called a federal mandate. And many federal mandates concern civil rights or environmental protections, and to help states pay for the cost associated with implementing national policies, the national government gives back some of the tax dollars it collects to the states in the form of grants. So when taxes are collected by one level of government, typically the national government, is spent by another, typically the states or local governments. We call that process fiscal federalism. And it wasn't really until the 60s, 70s, and 80s where it really began to grow majorly. Now we have categorical grants. Those are targeted for specific purposes. This gives national government control over how the states use the funds by imposing certain conditions. For example, a categorical grant may require that the funds be used for the purpose of repairing interstate highways, and that projects cannot pay below local prevailing wage. Also, you couldn't discriminate in awarding contracts for bridge building contracts. Another type of grant is called a block grant. These are given for broad areas such as criminal justice. These were developed in the 60s again, and these give the states more discretion over how the funds will be spent. Nevertheless, the federal government can exercise control over the state decision-making. Grants cannot be discriminatory based on race and so on. A lot of grants come to Cities like Laredo and these community development block grants go to usually specific areas to target helping low to moderate income areas of, let's say, Laredo. So they improve the water system or the sewer systems, things like that. And they do make up a large part of the budgets in states and local governments. 1/5 of state and local revenue comes from the national government. That's average. Um, that's about what it is in Texas. State and local taxes cover just over 1/2 of state and local spending, and 1/4 of it comes from fee for services. Like if you go to the golf course, you pay a fee, or you go to a park, you might pay a fee, those kind of things, or for water service. Here's a figure that shows you this, the breakdown. You can see that the blue area up at the top right, that's basically taxes to the federal government that comes back to us, to the states and local governments in revenue. The rest of it is for fees for services, this orange or red part. Then property taxes would be over here. Sales tax on each item sold, there's certain sales tax, and then individual income taxes here. Now we don't have that in Texas, so more revenue comes from sales tax and property tax and charges for services in Texas. Now, federalism during economic crisis can be problematical. State spending patterns tend to make economic booms more energetic and busts more painful. In a word, they are pro-cyclical. The federal government, they have no difficulty in spending more on welfare because they have the printing presses. So in a recession, the actions of the federal government are normally anti-cyclical. Oftentimes what the federal government does is it can withhold or give money to the states. Like in 1984, the national government forced the states to raise the drinking age 21 by threatening to withhold federal highway funds, kind of a blackmail. Supreme Court rulings on the minimum drinking age and the Affordable Care Act place some limits on the ability of the federal government to coerce the states. Now, sometimes the federal government just orders states to comply with federal authority outright. An example of this, they must grant persons equal protection of the laws. The cost of complying with all this is estimated at $29 billion annually, but it's probably much higher. Many of these mandates are unfunded or underfunded. Now, the debate over federalism is sometimes reduced to a debate over taxes. Which level of government will raise taxes to pay for government programs, which will cut services to avoid raising taxes? Now, states answer that question is they give citizens an option. They can move to a state with fewer services, lower taxes, or to a state with more services but higher taxes, like Connecticut. Political scientists call this model competitive federalism. State and local governments compete for businesses and citizens. People vote with their feet. They move to jurisdictions that offer a competitive advantage. The states that offer more services and lower taxes experience an increased population. You can see that the biggest winners of domestic wealth migration in 2018 were Florida, Arizona, and Texas, North and South Carolina, Nevada, Colorado, and so on. The losers were New York and California, Illinois. So people were leaving those states. That's shown on this map. You can see that the net winners were these yellow states, the Southeast and the Mountain West states, and Texas, of course. People were moving from these higher tax states like New York, Illinois, California, believe it or not, and moving to these states for better opportunities. Well, let me show you what I mean by this gentleman here who will talk about it.
We're supposed to be the United States of America, but in many ways, we're now divided into two very different nations. There is red state America and there's blue state America. The red states favor conservative, small government, free market policies, low taxes, light regulation, tough on crime policing, and worker freedom. Think Florida, Texas, Tennessee, Arizona, and Utah. The blue states favor a liberal left big government approach, high taxes, heavy regulations, high minimum wages, and mandatory union membership. Think New York, New Jersey, Connecticut, Massachusetts, Illinois, Oregon, and of course, California. Progressives like to argue that their big government, high tax policies are economically superior and thus better for the poor, minorities, and working class Americans than those of red states. Conservative policies, progressives contend, are culturally backward and tilted to benefit the rich. Let's test this thesis by comparing three of the largest red states, Florida, Texas, and Tennessee, with three of the largest blue states, California, New York, and Illinois. If progressive policies really work, then Americans should be rushing to get into the blue states. But just the opposite is happening. Americans are packing up their U-Hauls and heading to the red states. According to the New York Times, in August 2020, so many people wanted to leave New York City that moving companies were turning away business. They just couldn't handle the demand. This exodus may be accelerating, but it's not new. Over the last decade, the three big blue states each lost an average of 1 million people to other states, while the three big red states gained almost 1 million from other states. Makes perfect sense. Americans like freedom. Small government means more freedom, and freedom means opportunity. Let's say you're looking for a job. Over the last decade, Florida, Texas, and Tennessee have gained twice as many jobs as the progressive states. Not only that, but your money goes further in red states. According to a 2019 Tax Foundation study, your $100 stretches to $111 in purchasing power in Tennessee, while in New Jersey, it shrinks to $89. If you're a big corporation or a small company looking for a business-friendly environment, affordable housing, or maybe just a better quality of life, where are you going to go? The tough decision is not choosing a red state or a blue state. The tough decision is which red state to move to. Progressives like to say that this isn't about economics, it's about weather. The red states tend to be in the south and southwest where the weather is warmer. But that doesn't explain why so many people are leaving California, which has the best weather in the country. So what does explain the migration from blue states? Start with taxes. The two most populous blue states, California and New York, have the highest tax rates in America, while the two most populous red states, Texas and Florida, have no income tax at all. When taxes get too high, people move to where taxes are lower. The problem for the high tax states is that these people take their money, their ambition, and their employees with them. Then there's crime. Do blue cities do better than red cities? The answer, of course, is no. Of the 20 cities with the highest murder rates, 18 are run by left-leaning Democrats, and for the most part have been for decades. And these cities aren't getting safer, they're getting more dangerous. A good chunk of Minneapolis was burned to the ground as a result of riots following the death of George Floyd. Portland had over 90 consecutive nights of rioting, not peaceful protests, rioting. Seattle allowed an entire section of the city to declare itself an autonomous zone, a first in American history. Progressive governors, progressive mayors, progressive police chiefs run all of these cities and states. Ask any resident of Los Angeles or San Francisco about the rise in homelessness, and you'll get a litany of horror stories. Both cities, of course, have a long history of progressive mayors. How about keeping us healthy and safe? Surely the progressive states with their strict lockdowns did a better job saving lives from the coronavirus. Nope. Adjusted for population, as a resident of New York, New Jersey, or Illinois, you were 3, 4, or even 5 times more likely to die of the virus than if you lived in a red state like Florida, Texas, Georgia, Utah, or Arizona. Progressives and liberal Democrats may mean well. They certainly talk a lot about how much they care about the poor, minorities, and the working class. Yet somehow it's always the poor, minorities, and the working class who pay the price for their bad policies. That's why those who can move do move. Those who can't get stuck with the short end of the stick. Red state America is prospering. Blue state America is in meltdown. So where do you want to live? I'm Stephen Moore, economist at Freedom Works for Prager University.
Well, this chart from 2018, before all the rioting, doesn't anything but prove what his point. You can see where the people are leaving: California, Illinois, New York, going to those states, Tennessee, Florida, Arizona, Texas. So if a state offers more social services or lower taxes, may see an increase in population. People vote with their feet. Now, sometimes it's because it's cheaper to find a house, and housing has gone way up, suburban housing especially. Well, let's quickly review what is federalism. Again, it's a system of shared sovereignty between 2 levels of government occupying the same geographic region, with a constitution that gives the national government specific powers and the state governments specific powers. Many countries have it, but not as many as have the unitary form, where a centralized government gives power to local or subdivisional governments. Now, there are confederal forms in our history. The only one nowadays is the European Union. The advantages are several. It suits us. We can experiment. It allows political, cultural interests of regional groups to be expressed. There are disadvantages. Single groups can dominate a political unit. Now, in our Constitution, there are express powers, those specifically given to the national government. Then there are those implied by the necessary and proper clause. There's inherent powers necessary to ensure our survival. And there are limits on our powers, as in the first 8 amendments and Article 1, Section 9. Then there's powers given to the states. It's called reserved or police powers. And powers prohibited to the states. Then there's relationships between the states, like the full faith and credit clause. They can make compacts, but they have to be approved by Congress. But there is a supremacy clause, makes the Constitution supreme. Now, it hasn't been without a struggle, this whole relationship. People can challenge others in the courts, and that's been done throughout history, like in the McCulloch case involving which is supreme, the national government or state governments. In this one, the courts said, no, the Constitution clearly grants the national government the express power to form a national bank because of the necessary and proper clause. It gives it implied national power, and it is supreme. This one involved the interpretation of the Commerce Clause. Now, there's still been fights over tariffs, secession. This has led to like the dual federalism after the Civil War till the 30s, where federal and state governments maintain their diverse but sovereign power. But this ended with the 30s and created a new type called cooperative federalism, where the states and national government work together. And this expanded under the New Deal I'm sorry, the Great Society during the 60s, and in such areas as healthcare. Commerce Clause was used for Obamacare. Now, that doesn't mean there's still going to be people that see it differently, that feel that no, we should give states increased power in deciding how they spend their government revenue. That's called devolution. And sometimes the Supreme Court has said that the national government goes too far, like in the Lopez case or the Brady Handgun Act or the Woman Act of 1994. Sometimes they say, well, the federal government, you've got to do something. So they have to light a fire under the federal government, as in the Massachusetts case. The parties change their opinions on these issues as well. And finally, the fiscal side really deals with the allocation of taxes collected by the national government given to the state governments in categorical grants and block grants. And these are a big portion of the money spent by the state and local governments. The federal government can guide policy in the states because they have the ability to give or withhold these grants. This leaves the states with federal mandates. That means they are forced to comply. There's a big drawback because the cost may be high and funding may be insufficient. One of the interesting things that has happened in many years is competitive federalism throughout our history, really. People move with their feet. They move to jurisdictions that offer competitive advantage. State and local governments can tax, so many people will go to states like Texas that don't have an income tax, for example, as shown on this map. Okay, well, that concludes my presentation. Thank you for your kind attention.